Hello, everyone. Welcome to Save News TV. I am your host, AZ Hubbard, and I want to thank you so much for joining us today as we go over some impressive and important news on the update of TD Jakes and his lawsuit against Duane Youngblood. A lot has happened, and we are going to get into it and read the case. It is intriguing how the judge just knocked down. Oh, not going to tell you. You got to stay tuned so we can get this commentary with it. But as I was saying, TD Jakes, if you missed the video yesterday, has resigned from his position at the Potter's house and replaced his position with his daughter Sarah and his son-in-law Torrey Roberts. But for today, we're going to get into this lawsuit. So let's get at it, everybody. Do you have your coffee? Do you have your snack? Because this is a very, very good ruling, interesting by the judge. As always, we have no dog in either fight. We are just here to report the news. I will be giving my commentary in the midst of reading this, so hold tight and let's get to it. Okay, everybody, let's get into our read mode. As you know, it is 18 pages. So, well, you didn't know. Well, it's 18 pages. And I'm going to do some commentary in between this. And so let's get into it. Let's buckle up. All right. So this is Thomas Dexter Jakes, the plaintiff, versus Duane Youngblood. This is the memorandum opinion that Judge William S. Stickman, the fourth of the United States District Judge, ruled upon. Okay. So plaintiff Thomas Dexter Jakes is referred to throughout this, brought this action against defendant Duane Youngblood and 10 unidentified individuals, collectively defendants. Now, that's the interesting part because, you know, you have 10 individual unidentified defendants. So we're wondering who they are. We have had some um, hints from previous videos as who these unidentified defendants might be, but we have not had confirmation. So we will see as we go forward covering this case. Okay. EFC, ECF number 4. At count 1, brought against Youngblood, Jakes alleged that Youngblood engaged in libel per se. On count 2, brought against all defendants, Jakes alleged that defendants engaged in a civil conspiracy to commit defamatory acts. Youngblood filed a special motion to dismiss pursuant to Pennsylvania's Anti-Slapp statute. For the reasons articulated below, the court will deny Youngblood's motion. Now, let's go over a couple of things and then we're going to really get into the case. Number 1 is the count 1 um is that TD Jakes not only sued Youngblood, as I stated earlier, he had these 10 quote unquote defendants that were unnamed on the libel per se. Secondly, Youngblood filed an anti-slap motion. And an anti-slap, if you have been with us before, is is to prevent a person that has ample resources from filing cases against someone that is not financially able to fight against. That's pretty much what it is. But this is pretty much what an anti-slap is, and it is giving you the correct definition, not the condensed version. Strategic lawsuits brought against public participants or strategic litigation against public participant are lawsuits intended to censor, intimidate, and silence critics by burdening them with the cost of legal defense until they abandon their criticism or opposition. In a typical slap, the plaintiff does not normally expect to win the lawsuit. The plaintiff's goal is to accomplish if the defendant succumbs to fear, intimidation, mounting legal cost, or abandonment of the suit. So that's pretty much what, or simply exhausting and abandons the criticism. So, that's a slap case. And what Youngblood was purporting is that TD Jakes brought forth a slap case against him because he is not financially able to fight this, and and that TD Jakes really didn't expect to win the case, but he wanted to just silence him. So in turn, Youngblood filed an anti-slap case. So again, that's pretty much what that is. So let's again get into the facts and the procedural background. On October 28th, 2024, Youngblood was interviewed on the Larry Reed Live LRL online video podcast. The episode was entitled The Abused Become the Abuser. During the interview, Youngblood alleged that Jakes groomed and abused him when he was 18 or 9 to 19 years old. Specifically, Youngblood alleged that Jakes attempted to kiss him and subsequently called him on the phone and made statements regarding future encounters between Jakes and Youngblood. Youngblood stated that the encounter between himself and Jakes was absolutely destructive as damage. Youngblood described another conversation that took place with Jakes years later when Jakes allegedly stated, "My stock is rising. I would have had S with anyone at that time," in reference to the prior alleged interactions between Jakes and Youngblood. On November 3rd, 2024, a second part of LRL episode aired. In that episode, Youngblood repeated his previous allegations towards Jakes. Jakes subsequently brought this lawsuit under the court's diversity jurisdiction against Youngblood, alleging that Youngblood's allegations are patently false and defamatory. At count one, Jakes alleged that Youngblood's statement on October 28th and November 3rd episodes of LRL are libelous per se, in that they expose Jakes to contempt, ridicule, obloquy, trend, attend to affect. Jakes is in his profession as a trusted pastor and religious figure and accused of Jakes engaged in unlawful conduct. At count two, Jakes alleges that Youngblood, along with the 10 unidentified defendants, acted in concert to publish and broadcast a false claim that Jakes groomed and SA'd Youngblood on a podcast reaching over 100,000 persons, knowing that making such false claims on a podcast that reaches such a broad audience of listeners would harm Jakes. Youngblood filed a special motion to dismiss pursuant of Pennsylvania's anti-SLAPP statute, arguing that one, Youngblood's statements are protected public expressions. Two, Jakes cannot establish a prima facie case of defamation or civil conspiracy. Three, public policy and Pennsylvania's anti-SLAPP statute support dismissal of Jake's complaint. And four, Youngblood is entitled to attorney's fees. Youngblood also requests leave of file leave to file a cross complaint against Jakes and his son Jeremy Jakes in relations to a message Jeremy Jakes sent Youngblood via social media. Excuse me. Analysis. Excuse me. The court will deny Youngblood's motion brought under Pennsylvania's Uniform Public Expression Protection Act. Youngblood filed a special motion to dismiss pursuant to Pennsylvania's Anti-Slapp statute, the Uniform Public Expression Protection Act. Youngblood did not mention Federal Rule of Civil Procedure 12b-6, nor did he address Rule 12b-6 legal standard. Instead, Youngblood focuses exclusively on the Uniform Public Expression Protection Act. The Uniform Public Expression Protection Act is often referred to as an anti-SLAPP statute. Although SLAPP, an acronym for Strategic Lawsuit Against Public Participation, does not appear in the Act's title, the Uniform Public Expression Protection Act is considered an anti-SLAPP. SLAPP lawsuits are generally meritless suits brought by a large private interest to deter common citizens from exercising their political or legal rights or to punish them for doing so. Again, as I explained earlier. Of particular importance to Youngblood's motion, the court will address the application for each subsection in turn. For the reasons articulated below, the court holds that 1. 8340.16 is not effective. 2. 8340.15 is not applicable in federal court. And 3. 8340.18 is not relevant at this stage of litigation. Pretrial motion. Youngblood purports to rely on 42 PA CS 8340.16 as the mechanism permitting him to file his special motion to dismiss pursuant to Pennsylvania's anti-SLAPP statute. The court holds that 8340.16 has not yet taken effect. 8640.16a, party may file a special motion for dismissal of or judgment on the case, on the cause of action, or part of the cause of action, based on the party's protected public expression immunity. 42 PA CS 8340.16a. In the ruling on the special motion to dismiss, the statute directs the court to consider a special motion to dismiss, responses, and the evidence which can be considered on the motion of summary judgment. 42 PACS 8340.16 Uniform Law Comment. The Act establishes a procedure that shares many attributes with summary judgment. So, consistent with the summary judgment practice, parties should submit admissible, complete evidence such as affidavits, deposition, testimony, or tangible evidence for the court to consider. Nevertheless, 8340.16 is only effective if any of the following occur. I. Promulgation by the Supreme Court of Pennsylvania of the rule, similar in the form of PAC RCP number 4023, stating that the provision of 42 PA CS 8340.16 are not suspended. Promulgation by the Supreme Court of Pennsylvania of the direct letter of the address similar in form to INRE 42 PACS 1703 482 PA. I'm not going to read all of those numbers, stating that the provision of 42 PA CS 8340.16 are not suspended and do not violate Article 5 of the Constitution of Pennsylvania. Promulgation by the Supreme Court of Pennsylvania of procedural rules providing substantially the same content as the provision of 42 PACS 8340.16. Okay. HB 1466 number 2024-723 at 5/2024. The Supreme Court of Pennsylvania has not promulgated any rules or issued a direct letter of address regarding 8340.16 or any similar provision. Thus, 8340.16 is not effective and has no bearing on this litigation. It is not operative law. Youngblood purports to file his special motion to dismiss pursuant to 8340.16 mechanisms. His motion must fail on procedural grounds as a subsection under which it was brought is ineffectual since 8340.16 is not good law. Youngblood's motion may not proceed under this subsection. Okay, so in essence, the judge is denying his motion for anti-SLAPP due to bad law of this subsection. Okay, so grant for immunity, which is B. Youngblood alleges that he is entitled to immunity and judgment as a matter of law under 42 PACS 8340.15 because his statements are supported by affidavits, public records, and collaborating testimony. And Jakes has not demonstrated actual malice or falsity. ECF number 35-2, pages 15 through 16. Youngblood repeatedly states that Jakes has, quote, failed to provide credible evidence, unquote, to meet the burdens of 8340.15. Youngbloods filed a multitude of exhibits with the courts that allegedly supports the truthfulness of his statements. ECF numbers 35 through 3 through 35 through 24. Jake counters that 8340.15 does not apply in federal court because it conflicts with federal rules of civil procedure. Thus, the first issue before the court is whether a federal court exercising diversity jurisdiction may apply 8340.15. Even assuming that 8340.15 could apply independently of 8340.16, the court holds that 8340.15 does not apply in federal court. It sounds like they just was quoting some, bad statutes here. I'm just saying. What do you all think? This is my pen, everybody. This is my pen. Even, okay. The court acknowledges that there is a disagreement amongst courts as to whether a federal court exercising diversity jurisdiction can apply a state's anti-SLAPP law. While other states' laws are not identical to 8340.15, these cases provide persuasive guidance to the court. CF Abbas versus Foreign POLY Group LLC with Godwin versus Shinex, holding that Maine's anti-SLAPP law does not conflict with Rules 12 and 15 and therefore applies in federal court. In Abbas, the United States Court of Appeals for the District of Columbia held that federal court exercising diversity jurisdiction must apply Rules 12 and 56 instead of DC anti-SLAPP's action special motion to dismiss provision. Abbas 783 F3D at 1337. The district court determined that the DC anti-SLAPP Act conflicts with federal rules by setting up an additional hurdle a plaintiff must jump over to get to trial. ID at 133.4. See also in reference Johnson and Johnson talcum powder products manufacturing sales practices and procedures liability litigation, holding that federal courts must apply Rules 12 and 56 instead of California's anti-SLAPP statute. Cox versus Watkins, holding that Texas anti-SLAPP statute does not apply in federal court. Coburn versus Cable News finds Abbas persuasive, and holding Rule 12 answers the same question as Georgia anti-SLAPP statute. The court finds Abbas reasoning persuasive, section 8340.15, and other anti-SLAPP statutes with similar provisions is procedural rule, not a substantive law. It creates a mechanism for defendant to resolve a case pretrial, much like federal rules of civil procedure 12 and 56. Pursuant to Erie doctrine, the federal court sitting in diversity must apply state substantive law and federal procedural law. Chamberlain versus Giapapa. This substantive procedural dichotomy of Erie rule must be applied with the objective that in all cases where a federal court is exercising jurisdiction solely because of the diversity of citizenship of the parties, the outcome of the litigation in federal court will be substantially the same. So far as legal rules determine the outcome of litigation, it would be if tried in state court, ID at 158-59. Alterations in original, quoting Garrity Trust Company versus York. This outcome determinative test, however, should not produce a decision favoring the application of the state rule unless it furthers one of Erie's twin aims: discouragement of forum shopping and avoidance of inequitable administrative administration of the laws. Hammer versus Plummer. Consistent with these aims, the court must apply a three-part test to decide whether a state law or rule is substantive or procedural for Erie purposes. Legums Reddings versus Estate of Sugarman. First, the court considers, quote, whether there is a direct collusion between a federal rule and the state rule or rule that the court is being urged to apply, unquote. If there is a direct conflict and the federal rule is constitutional and within the scope of the Rules Enabling Act, the court must apply the federal rule and end the analysis. Chamberlain. In other words, a federal court exercising diversity jurisdiction should not apply a state law or rule if one, a federal rule of civil procedure answers the same question as the state law or rule, and two, the federal rule does not violate the Rules Enabling Act, Shady Grove Orthopedic Association's PA versus Allstate Insurance. The court holds that there is a direct conflict between 8340.15 and Rules 12B6 and 56. For the category of cases that is covers 8340.15 essentially supplements the rule 80 the rule 12B6 motion to dismiss standards with rule 56 summary judgment standard. Rules 12B6 and 56 help form the integrated program for determining whether a grant pretrial judgment in cases in federal court. Cliff versus Trump University and Makeoff versus Trump University. Watford J. dissenting from denial of rehearing en bloc, stating Rule 12B6 and 56 establish a exclusive criteria for testing the legal and factual sufficiency of the claim in the federal court. Y'all, this is like really technical stuff here. So it might get a little boring, but you know, we got to go through it. We got to read the case and we will go through it. And really, pretty much it's sounding like, because this is my first read through, also, you all know that I do not pre read these. I just pull it up and read it with you all. And we do the thing. We do the thing. So stay with me and it will get better. Under Rule 12B6, a plaintiff can overcome the motion to dismiss by alleging facts sufficient to the state a claim that is plausible on its face. See Bell Atlantic Corp versus Twombly. A well pleaded complaint may proceed even if it strikes a savvy judge that actual proof of the facts alleged is improbable. The court must accept all well pleaded factual allegations as true and view them in the light most favorable to the plaintiff. Okay, I'm going to stop here. So, when someone is, our regular viewers know when someone files a lawsuit, it doesn't mean what they put in the lawsuit is true. This is just their allegations. But when the judge looks at the case, as the judge stated in this particular circumstances, that when the plaintiff pleads a case, the judge may proceed even if it strikes a savvy judge that actual proof of facts is improbable. The court, now this is the key, the court must accept all well pleaded factual allegations as true and view them in the light most favorable to a plaintiff. And this is not just the case with TD Jakes, this is the situation with all cases. Okay. So if you file a lawsuit against someone, if it is well pleaded, a well established case, then the judge comes in with the onset, not favor, not just this case, with the he comes in or she comes in with the onset that what the plaintiff is saying is true and must view it in the most favorable light. Okay. All right. So see Doe versus Princeton University, also Fowler versus UPMC Shady Side. Further, at the motion to dismiss stage, the court may not consider matters extraneous to the pleadings unless the documents were integral to or explicitly relied upon in the complaint. See Burlington Coat Factory, section litigation. If the complaint survives the motion to dismiss, a party may move after discovery but before trial for summary judgment under Rule 56. Summary judgment is appropriate if the pleadings, depositions, answers to interrogatories, and admissions on file, together with affidavits, if any, show that there is no genuine issue as to any material facts and that the moving party is entitled to judgment as the matter of law. A factual dispute is genuine only if there is sufficient evidentiary basis on which is reasonable fact finder could find for a non-moving party, and it is material only if it has the ability to affect the outcome of the suit under the governing law. Con- Culture versus City of Books. In considering the motion for summary judgment, the district court may not make credibility determinations or engage in any weighing of the evidence. Instead, the non moving party evidence is to be believed, and all justifiable interferences are to be drawn in his favor. Marino versus Industrial Crating Company. If the party fails to make a showing sufficient to establish the existence of an element essential to the party's case on which that party will bear the burden of proof at trial, Rule 56 mandates the entry of summary judgment. Sealet Text Corporation versus Catret. A complete failure of proof concerning an essential element of the non-moving party's case necessarily renders all other facts immaterial. Katz versus Aetna Casualty and Insurance. A person is immune from civil liability for a cause of action based on protection, public expression, if any of the following paragraphs apply. 1. A party asserting a cause of action based on protected public expressions fail to 1. Establish a prima facie case as to each essential element of the cause of action, or 2. State a cause of action upon which relief can be granted. 2. There is no genuine issue as to any material fact that the person against whom the cause of action based a protected public expression has been asserted is entitled to the judgment as a matter of law in part or in whole. This section permits the court to consider whether there are genuine issues of material fact and seemingly requires the court to look outside the pleading to other evidence and documents submitted by the parties. It imposes evidentiary weighing requirements not found in federal rules and operates largely with pre-decisional discoveries. Thus, there is a direct conflict between 8340.15 and Rules 12 and 56. The Uniform Law Comment to 42 PA 8340.14 acknowledges that the statute operates in a procedural manner, specifically by altering the typical procedure policy parties follow at the outset of litigation. Nevertheless, the commentary argues that the rights the Act protects are most certainly substantive in nature. The Act's procedural features are designed to prevent substantive consequences, the impairment of the First Amendment rights, and a time and the time and expense of defending against litigation that has not been demonstrable merit. The court does not believe that a procedural rule protecting a substantive right is, by virtue of right it is protecting, transformed into substantive law. The statute exists to spare those who exercise their free speech from unwanted and harassing litigation. However, 8340.15 pursues this policy goal through procedural means. The substantive free speech rights underlying the statute exist entirely independent of 8340.15. Section 8340.15 merely provides a procedural mechanism for speedy dismissal of meritless lawsuits. In some, in some, in some, Rules 12 and 56 answer the same question as Rules 8340.15, Rules 12 and 56, therefore govern in diversity cases in federal court, unless they violate the Rules Enabling Act. The rule holds that Rule 12, 56, and 56 do not violate the Rules Enabling Act. The Rules Enabling Act empowers the Supreme Court of the United States to prescribe general rules and practices, procedures, and rules evidence for cases in the lower federal courts. A federal rule of civil procedure violates Rules Enabling Act if it abridges, enlarges, or modifies any substantive right. So far, the Supreme Court has rejected every challenge to federal rules that it has considered under Rules Enabling Act. In determining whether a federal rule violates the Rule Enabling Act, the United States Supreme Court of Appeal for the Third District has stated a rule of procedure does not run afoul of 2772B statutory limitation merely because it affects the litigants' substantive rights. Most procedural rules do. Shady Grove Orthopedics PA versus Allstate Insurance. As Justice Scalia elaborated, what matters is what a rule itself regulates. If it governs only the matter and the means by which the litigant rights are enforced, it is valid. If it alters the rules of decision by which the court has adjudicated those rights, it is not. See Mississippi Pudge Corp versus Mapre. Interfaith Community Org versus Honeywell International. Rules 12 and 56 are valid under Rules Enabling Act because they define the procedures and determining whether a claim is alleged in a sufficient manner in a complaint and whether there is a genuine dispute of material fact sufficient to warrant a trial. These rules affect only the procedure of enforcing litigants' rights and not the rules themselves and thus really regulate procedure. Carbon Carbone versus Cable News Network. In accordance with the Erie Doctrine and Shady Grove, the court holds one, there is a direct conflict between 8340.15 and Rules 12 and 15, and two, Rules 12 and 56. I don't know why I said 15. 56 are constitutional and within the scope of the Rules Enabling Act. The court must apply Rules 12 and 56. The procedural mechanism established by 8340.15 cannot apply in federal court. Since the court cannot apply 8340.15, the court will not consider Youngblood's argument brought under that statute. Whew, that was a lot of reading. So in other words, that is addressing the point of that he was making. It sounds to me like it, just improper law has been pleaded to the judge throughout this case. You all tell me. I'm just reading it and giving my opinion. Again, I don't have a dog in this fight either one way or the other, but this is what this judgment from the judge is sounding like, that that the attorney Blackburn used improper law to plead Youngblood's case. What do you all think? Are you all gathering this from that? Okay, C. Youngblood seeks fees pursuant to 42 PA CS 8340.18. Awards attorney fees, costs of court costs, expenses of litigation to the defendants who engage in protected public expression if the court finds that the defendant is immune under 8340.15 or opposing parties voluntarily discontinues the action. On the other hand, if the court determines that the party's assertion of protected public expression immunity is frivolous or filed solely with the intent to delay the proceeding, the court shall award the opposing party attorney fees, court costs, the expense of litigation incurred, and imposing the assertion of protected public expression immunity. Noted in the prior section, 42 PA 8340.15 and 8340.16, one, are not applicable in federal court, and two, not effective law. Consequently, the court will not make any findings with respect to whether Youngblood or Jakes is the prevailing party. The court holds that 8340.15's award of fees is inapplicable at this stage of litigation, and at this time it will not reach the issue of whether 8340.18 is applicable in federal court. In other words, you ain't getting paid. Not now, not until I make my whole ruling in this, okay? Two, there is no motion to dismiss pursuant to Rule 12B6 pending before court. Whoa, okay. Now it's getting down to the nitty gritty. We're going to find out when the judge makes his real thing. All of this was the preliminary. Now it's going to get start to get real juicy. Youngblood's special motion to dismiss pursuant to Pennsylvania Anti-Slapp statute is based entirely on uniform public expression protection. In his motion and supporting brief, Youngblood does not mention Rule 12B6, the governing rule at this stage of litigation. Moreover, Youngblood's motion is reliant on the summary judgment like standard 8340.15 and 8340.16. The court will not reframe Youngblood's motion as a Rule 12b6 motion. In other words, judge says, you got the wrong numbers. You pleaded under this law, and make I will not reframe it. I will not remake it to put it over where it's supposed to be. In other words, that's pretty much what the judge said. Youngblood relies on sworn affidavits to allege cooperation, to allegedly cooperate his statements and support his argument. The court may not consider documents outside the pleading under Rule 12b6, subject to certain exceptions which are not applicable here. In Burlington Coat Factory litigation, moreover, Youngblood's argument are fundamentally incompatible with Rule 12b6 standard. For example, Youngblood argues that Jakes has not presented admissible evidence to prove that Youngblood's statements were false and made with malice. Plaintiff cannot meet the burden of proving falsity or demonstrating that the defendant's statement lacks substantial truth, emphasis added. Plaintiff has failed to present admissible evidence of reputable damage directly resulting from defendant's statements. Youngblood further contends that Jakes fails to establish by clear and convincing evidence that Youngblood acted with actual malice. Youngblood's motion, based on the Uniform Public Expression Protection Act, fundamentally diverges from Rule 12b6 standard. At the motion to dismiss stage, Jakes does not have a burden to present admissible evidence. Before discovery and trial, Jakes has no obligation to prove any of his claims by clear and convincing evidence. His burden at this stage is merely to allege sufficient facts that, if accepted as true, state a claim of relief plausible on its face. Moreover, Youngblood's arguments rely on matters extraneous to the pleading that the court may not consider. So, with that being said, again, I'm not an attorney, but I'm just going to give you, just my experience and stuff with this. At this part of the game, Jakes don't have to present that evidence. And remember when we discussed before, just like the judge's ruling right here stated, that the judge, when a plaintiff files a lawsuit, if it is strong, it's a strong case that the court presumes that the plaintiff, the moving party, is the one that is the moving party at the initial filing. Okay. In this particular part here, Youngblood is a moving party, but they have to take the assumption that what the plaintiff has said in their initial complaint is true and factual if it's a case that is strong on foundation. Remember, we discussed that. The judge wrote that in this earlier. Okay, let's get back to it. Given that Youngblood's motion is incompatible with Rule 12b6 standards, the court cannot reframe Youngblood's motion into a motion to dismiss based on Rule 12b6. The court's role is not to craft arguments for the parties. Oh, boo! Okay. So the judge now is, like I said, this is where it's starting to get good because the judge now is really starting to lay down. Like he's saying, look, this is not my responsibility. This is not court responsibility. to write your case, to rewrite it for you. I'm not going to do it. Get somebody else to do it. It is the responsibility of neither the district court nor this court to make the parties' arguments for them. Therefore, we will not engage in a free-willing investigation into a legal issue without meaningful briefing on the subject. Okay. This judge, get a sip of coffee. This judge is really laying it down. He's like, look, get somebody else to do it. It is not my responsibility. I'm not doing it. Okay? That's what he said. That's what he said. That's what he said. Okay? He says, it is the parties' duties, not the courts. It's the parties' duties, not the courts, to present legal authority and arguments in support of a motion. The court will dismiss Youngblood's motion because it relies on statutory provisions that are not applicable in this litigation. The court will not reframe Youngblood's argument to fit within Rule 12b6 or Rule 56 framework. If Youngblood wishes to file a motion to dismiss based on Rule 12b6 or Rule 56, he may do so, provided that his filings comply with applicable federal rules of civil procedure. Wow. 3. Woo, this judge is getting down now. Youngblood does not require leave to file a cross claim against Jakes. The court will deny Youngblood's motion to file cross complaint against Jeremy Jakes. It sounds like Duane Youngblood is getting slapped down, turned down all the way around. Every action there's a no. It's a no from the judge. No, I'm not going to do it. It's not happening. Get somebody else to do it. Okay. Youngblood requests the court's leave to file a cross complaint against Jakes and his son Jeremy Jakes in relation to a message Jeremy Jakes allegedly sent to Youngblood via social media. The court interprets this as a request to file a counterclaim against Jakes and a request to join Jeremy Jakes as a counterclaim defendant. First, the court holds that Youngblood does not require the court's leave to file a counterclaim against Jake at this stage in litigation. Second, the court holds that whether Youngblood may file a counterclaim against Jeremy Jakes, a non-party, is not fully briefed. The court will address each proposed claim in turn. Counterclaim against Jakes. Hey, whew. Federal Rule of Civil Procedure, Rule 13, permits a party to file a counterclaim against an opposing party in its answers. There is no requirement to seek leave from the court to file a counterclaim against an opposing party unless the party is seeking to amend its previous filed counterclaim or to file a counterclaim that matured or acquired after the party filed its answer. Youngblood has not yet filed his answer. He may file a counterclaim against Jake in his answer under Rule 13. He does not need to obtain leave from the court to file this counterclaim. Okay, Judge Stigman. B. Jordan Jeremy's Jake as a counterclaim defendant. Youngblood alleged that Jeremy Jakes sent him a message on social media on November 3rd, 2024, stating, quote, "You might be in dangerous territory, comma, Duane, dot, dot, dot. Just be careful," unquote. Youngblood seeks to join Jeremy Jakes as a party to this litigation based on this conduct. Federal Rules of Civil Procedure 19 and 20 govern the addition of a person as a party to a counterclaim. Rule 19 determines when joiner of a party is compulsory. Rule 20 applies to permissive joiner of parties. Thus, the first issue the court must address is whether Jeremy Jakes is a necessary party under Rule 19A or whether his joiner is permissive. A required party is a person who is subject to service of process and whose joiner will not deprive the court of subject matter jurisdiction, must be joined as if the party A, in a person's absence, the court cannot accord complete relief among existing parties. Or B, that the person claims of interest relating to the subject of the action and is so situated that deposing of the action in the person's absence may A, 1, as a practical matter, impair or impede the person's ability to protect the interest, or 2, leave an existing party subject to substantial risk of incurring double, multiple, or otherwise inconsistent obligations based because of this interest. Courts treat causes 1 and 2 as disjunctive. Thus, if either subsection is satisfied, the absent party is a necessary party that should be joined if possible. Under Rule 19A 1A, completeness is determined on the basis of those persons who are already parties and not as between a party and an absent person whose joiner is sought. Angus versus Royal Maccabees Life Insurance. Jake's claims against Youngblood relates to Youngblood's statements on 2 LRL episodes. Youngblood's proposed claim against Jeremy Jakes relates to an alleged social media message, which may have had a tangential relationship to Youngblood's statements on LRL. In other words, Youngblood's proposed claim against Jakes arise out of different transaction or occurrence than the subject of Jake's claim against Youngblood. The courts hold that if Jeremy Jakes is not joined to this litigation, the court may still accord complete relief between Jakes and Youngblood. Further, Jeremy Jakes is not a necessary party under Rule 19A 1B, as Jeremy Jakes does not claim any interest in the subject matter of this action, his father's claim against Youngblood. Thus, Jeremy Jakes is not a necessary party, and his joiner is governed by Rule 20. Rule 20 states persons may be enjoined in one action if as a defendant if A, any rights of relief is asserted against them jointly, severally, or in an alternative with respect to or arising out of the same transaction, occurrence, or series of transaction or occurrences. And B, any question of law or fact common to all defendants will arise in the action. The proposed Rule 20A is to promote the trial convenience and expedite the final determination of disputes, thereby preventing multiple lawsuits. Bigelow versus Boeing. Internal citations and quotation marks omitted. Joiner of parties' claims and remedies are strongly encouraged. Accordingly, courts liberally construe a joiner provision of Rule 20, referring to the liberal joiner provision of Rule 20. Neither Youngblood nor Jakes address Rule 20 standards in relation to the proposed counterclaim against Jeremy Jakes. Given that this issue has not been fully addressed by the parties, the court will deny the motion to join Jeremy Jakes as a counterclaim defendant without prejudice until this issue is properly placed before the court and fully briefed by the parties as discussed above. The court cannot and will not craft arguments for the parties. So the judge ruled that part about Jeremy Jakes without prejudice, which means that if anything changes, he can bring forth that again. Conclusion. For the foregoing reasons, the court will 1. Deny Youngblood's special motion to dismiss pursuant to Pennsylvania's Anti-Slapp statute. 2. Deny Youngblood's motion to file counterclaim against Jakes as mute. And 3. Deny Youngblood's motion to file counterclaim against non-party Jeremy Jakes without prejudice and order the court will follow. All righty then. Well, okay, everybody. That was a long read, and I thank you for staying with me. I just want your thoughts in the comments on what you thought about the judge ruling on Youngblood's request to for an anti-slap case. It appears that his attorney Blackburn has used inappropriate statutes and laws to plead the case in the filing, and that the judge said, "No, we're not doing this. I'm not doing this. This is the wrong statute. This is the wrong law. And it is not the court's responsibility nor my responsibility to get that done." Okay. And he also said to basically get somebody else to do it. Okay. So it appears to me that it is pretty much on Youngblood to file the 12B6 motion, because what he's filed is not going to fly. So anyway, I don't have a dog in this fight. I'm just reporting the news and giving commentary when need be. So let me know what you all think. Hopefully you all did not miss the video from yesterday regarding TD Jake stepping down. If you did, it should be up here. Um, or it should be down in the comment section, and you can look at it with the entire playlist of videos regarding this case. So tell me what you think, everybody. Get in the comments. Don't forget to like, share, and subscribe. Like, share, and subscribe. Thank you very much for tuning in to Save News TV. We will continue to cover this. And of course, stay tuned for some other videos. We want to make sure that you inform of our radio station. It's been in everywhere for the longest time. Is SaveNewsRadio.com. And make sure you just click at the headphones, click the play button. You can listen to Christian music all day long. We have all the best music playing. And so, a lot of people have said, I don't promote our other things up here. So I promote it, even though I play a video at the end showing where all of our social media things are. But SAVEDnewsradio.com. Also, if you are an artist and you want to submit your music for us to play on our radio station, you need to go to savenewsradio.com/submissions, and you'll be able to follow the instructions on how to submit your music to get into regular rotation. Also, make sure you go over to savenews.com/magazine and subscribe to our free monthly magazine. So we have a lot of stuff going on, and we're going to play the video now so you can see all of our other sites. Follow us all on social media, like, share, subscribe, and comment here. And if you also, which a lot of people, and I want to thank everybody for donating to Save News. We appreciate it because it definitely helps us to continue to bring you the comments and the videos and all of the things, all of the good things. And I also, at the end of the video, put up how you can donate to Save News, and we appreciate it. And no, we are not tax deductible, but you enjoy our content and you want to continue to see it. Well, we ask you to drop us a nickel or two or some money. Uh, Either through PayPal or Cash App or Venmo. Venmo's sort of crazy, but okay, you can do it there. And also you can do it through YouTube also. But anyway, make sure you like, share, and subscribe. We thank you so much for tuning in, and the videos are to follow. Thank you. Bye. We'll talk to you later. I'm riding. I'm writing lines to lift his name, no need for fame. My spirit fed, his word is spread, saves the aim. Pen to paper, truths I scribe, a soulful vibe. To glorify the Most High, let's amplify.